Welcome to this class on women's rights. My name is Lidia Casas and I am a law professor at Diego Portales University. We will talk about historical antecedents, the evolution of international human rights instrument with respect to women, and the core content of CIDO, the main international convention on women's rights. Historically, women have suffered from the exclusion, restriction, or denial of rights. The rights to have access to education, to be considered a citizen with equal rights to vote and to run for office, to control their fertility or not to be arbitrarily discriminated upon, whether within the marriage or in other ambits, among others, have been systematically infringed throughout history, just because of women's sex or gender. Women's biology may also affect them adversely if proper health care is not available to them. In addition to sex and gender, other factors may compound the obstacle for the enjoyment of women's rights. They include ethnic origin, race, and age. Such discriminatory treatment, both by public and private actors, has been historically justified on stereotypes about women's and men's roles, their respective status in society, and generally what it means to be a man or a woman. There are specific types of violence perpetrated in some regions of the world against women, such as female genital mutilation. This practice exemplifies an irrational fear towards women's sexuality and a cruel attempt to control it. However, up to the present date, not all forms of ill treatment against women have been internationally recognized as a human rights violation. In the struggle for women's rights, the first proposals and manifestos were produced in Europe in the late 18th century. The movement for women's equality grew much stronger in the 19th century, embracing causes such as universal suffrage, property rights for the married women, and women's access to all levels of education. This struggle began to produce results starting in the late 19th century and during the first half of the 20th century, particularly in Europe, North America, and although more gradually in Latin America. In recent decades, the women's rights movement has grown even stronger, and it uses to cast its demands in the language of human rights. The United Nations, from its inception, worked towards the recognition of women's human rights. In fact, the Charter of the United Nations affirms faith in fundamental rights, in dignity and worth of the human person, in the equal rights of men and women, and stipulates that all people, irrespective of their sex, shall enjoy human rights. Although women's rights and the principle of non-discrimination because of sex has formed part from the beginning of all international human rights covenants and non-binding declarations, these documents did not address the specificity of discrimination against women. Progressively, the need to remedy this situation was recognized and specific treaties were agreed upon. The first document adopted by the General Assembly of the United Nations on the status of women was the Convention on the Political Rights of Women of 1953. To date, 122 countries are parties to this convention. Other instruments also deal with women's rights, but they are limited in scope. For instance, the International Labour Organization adopted conventions to protect women from poor working conditions, such as night work, or from the arbitrary discrimination, stating there ought to be equality between the sexes with respect to remuneration. The acronym CEDAW stands for Convention on the Elimination of All Forms of Discrimination Against Women. It was adopted in 1979. It is a comprehensive document, a true charter of women's rights. It was preceded by the UN Declaration on the Elimination of Discrimination Against Women of 1967. CEDAW's Article 1 defines discrimination against women as any distinction, exclusion, or restriction made on the basis of sex that has the effect or purpose of impairing or nullifying the recognition, enjoyment, or exercise of human rights by women on the basis of equality with respect to men. This definition does not require the intent to discriminate. It suffices that discrimination is the actual effect of laws, regulation, practices, or customs on women, even if they are seemingly gender neutral. The elimination of discrimination is the core obligation of CEDAW. CEDAW is built upon the basis that discrimination is a consequence of the stereotypes found in culture, religion, and customs. CEDAW establishes the obligation of state parties to undertake measures to promote cultural changes. It also requires dismantling all barriers that place women in a subordinate position. Such measures may involve legislative steps to ameliorate the conditions of women. State parties must inform the CEDAW Committee about the actions taken to combat discrimination. CEDAW includes the obligation of states to take immediate and incremental steps. The specific language is to take all appropriate measures, without much definition of what it encompasses. In the end, the actions undertaken by states must be assessed according to their effect in achieving the goals of equality between the sexes and of enhancing women's status within society. Many states have made reservations to the obligations contained in CEDAW. Generally, they consist of declaring that they are exempted to abide by certain CEDAW provisions which are in contradiction to their domestic laws. Some of the reservations are based on an alleged inconsistency between the obligations of the treaty and religious precepts. For instance, the United Arab Emirates made a reservation with respect to Article 2F of CEDAW because it is of the opinion that it violates the rule of inheritance prescribed by the Islamic law known as Sharia. The domestic legal order is also invoked as a reason not to adopt an obligation. For example, Austria made a reservation as to the special protection of working women, declaring that it would comply with such obligation within the limits established by its national legislation. Some of these reservations contradict the core of CEDAW because they do not accept the equality of men and women in family life. They are incompatible with the object and purpose of the covenant and therefore should not have validity. Granted, the process of overcoming cultural prejudices can be slow. It is up to a persistent effort by states, international bodies, and the civil society to overcome the reticence of some states to comply with the prescription of CEDAW. In 1999, an optional protocol to CEDAW was approved. According to it, individual complaints or communications may be presented to the Committee of CEDAW, the expert body which supervises compliance with the Convention. CEDAW guarantees women's freedom from discrimination, whether from the state or from private actors, in all areas of public life. It stresses that discrimination must be confronted both in the public and in the private sphere. This is relevant because women's rights are routinely infringed in the family ambit, which has traditionally remained beyond public scrutiny. CEDAW establishes both civil and political rights on one hand, and economic, social, and cultural rights on the other, rights that up to that point were treated separately by main UN covenants. In doing so, CEDAW actually stresses the interdependence of these two sets of rights. This convention must be complemented with the general recommendations issued by the Committee of CEDAW, which, although not binding, are an official interpretation of the Convention. CEDAW encourages states to implement special measures to accelerate de facto equality among men and women, Article 4.1. This reflects an awareness that it is not sufficient to adhere to a formal statement of equality among men and women. Given the weight of long history of prejudice, special measures or affirmative actions to overcome discriminations are needed. The special measures must be temporary. Their duration may not extend beyond the accomplishment of the goal of de facto equality. Such special measures are not considered discriminatory. The CEDAW Committee, in its General Recommendation Number 5 of 1988, encouraged states to make more use of special measures to advance women's integration into education, the economy, politics, and employment. In its General Recommendation Number 8, it called states parties to adopt direct measures to ensure women, on equal terms with men, the opportunities to represent their government at the international level and in international organizations. Some special measures do not constitute affirmative actions. For instance, those related to the promotion of cultural change through educational campaigns, so as to try and modify the stereotypes that maintain women in a subordinate condition. One of the most egregious practices against women is violence. CEDAW does not make a special mention of this practice. However, the CEDAW Committee, in its General Recommendation Number 12 of 1989, states that violence against women occurring within the family, at the workplace, or in any other areas of social life is a form of discrimination. The Inter-American Human Rights Protection System contains a special treaty, the Inter-American Convention on the Prevention, Punishment, and Eradication of Violence Against Women, or Belém do Pará Convention. The Inter-American Human Rights Commission has stated that the general human rights obligations to respect and ensure require due diligence on the part of state to investigate and sanction the perpetrators of violence, whether it is committed by state agents or by private ones. When state agents perpetrate the violence, this may amount to torture. The Inter-American Court has ruled that sexual attack must be considered cruel, inhuman, or degrading treatment. Thanks for your attention. Please visit our website mucchile.com.